Hi everyone. So as promised, this is a recording of the week 9 lecture on Streets Drainage and Building Act, 1974, also known as Act 133. And this act is the primary legislation. So together with the primary legislations, normally there will be what we call subsidiary legislation, to be read together with the primary legislation. So Streets Drainage and Building Act 1974, Act 133, the accompaniment subsidiary legislation is the Uniform Building Bylaw 1984. So that means the primary legislation sets out the broad details or the broad provisions regarding building control in Malaysia. All the details, the small things, the details are contained in Uniform Building Bylaw 1984. But we're not going to touch in detail. Okay, we're not going to into detail. The building control in Malaysia is sufficient enough for me to discuss the broad provisions contained in SDBA. Okay, the short form of Streets Drainage and Building Act is SDBA, and I will use the short form, SDBA, interchangeably with Act 133. They both mean the same thing. Okay, SDBA or Act 133. And this one, Uniform Building Bylaw, is UBBL. Okay. Now, the lecture will be divided into 4 components, beginning with overview of SDBA and UBBL. And then I'm going to talk about the functions of SDBA. And then we are going to touch on building control, of which I'm going to just discuss 2 things, building plan approval process and also CCC, which is the certification process for new buildings, to certify that the new buildings are safe for occupation and in the older times fit for human habitation. But nowadays is more on certification that the building is fit for occupation. And the full name of CCC is Certificate of Completion and Compliance. And finally, as promised before, we are going to use Highland Towers as the case study to showcase building control or building law in Malaysia, focusing on the role of local authorities in building control. In this case, their liability or building failures. Okay, so building failure is one of your tutorial topics, which I have provided on Spectrum. Okay, have a look on Spectrum after this, the 4 forum topics that you need to participate in. Okay, now, the first component, which is overview of SDBA and UBBL. Now, what is SDBA or Act 133? It consolidates, actually, it brings together all the different regulations and different provisions and different subsidiary legislations, all the laws relating to street drainage and building in local authority areas in Peninsular Malaysia only. Okay. In other countries, their building law is also known as building code. Building code. But in Malaysia, we use the Streets Drainage and Building Act, ACTA, to be read together with the Uniform Building Bylaws. So if you have heard before, okay, the term building code in other countries, same thing lah. Now, this act makes the maintenance of street drainage and building the responsibility of both local authority and also the private sector. So we will see later on, especially in the certification or in the construction of new buildings. The role not evenly divided, but we can see that more responsibility has been given to the private sector to ensure that the building is safe for occupation. But not only for safety, building law is implemented primarily to safeguard the safety of its occupants, of its users, of the building's users, building's occupants, building's owners, and things like that. But also, on top of ensuring safety, there are other reasons why we implement building laws. For instance, this one, health Health, safety, two different things. Yeah. When we talk about safety, we talk about the structural soundness, maybe, of the occupant. Sorry, of the building. If the building is structurally sound, then it's safe for the occupants to use the building. Okay, that's why we need to calculate the loading and things like that. Yeah, loading of the flooring and the beam, the load bearing columns and things like that for the buildings to ensure the safety. One other aspect is the health of the occupants. You've heard of sick building syndrome, haven't you? Have you heard of that before? If you haven't, you can Google sick building syndrome, which is one of the reasons or one of the causes may be poor ventilation in the building. Or there are so many other things, many other factors that can contribute to sick building syndrome. Actually, the building is not sick. It's the occupants who are sick. So the symptom you can see on the occupants rather than the building itself. But a bit misnomer, kan, a bit misleading lah. But anyway, it's quite interesting, yeah, to go and learn about sick building syndrome. But anyway, health, security, safety just now, health, safety, yeah, I mentioned welfare of occupants as well. Why do I mention welfare here? Some of the buildings must be made safe for people with disability. So you have building standards that that what you call that provides, for instance, for blind people, what kind of what kind of aids, not visual aids, what kind of aids in terms of if you go into some buildings, you may find path for the blind, for the blind to use. They use specific tiles, for instance, yeah, for the users with who are visually impaired, and also for other disabilities, for instance, people with wheelchair. People who have hearing disabilities. If there is a fire inside the building, they cannot hear the alarm, for instance. What kind of things to cater for these kind of people with disabilities? So that's why it's welfare of occupants as well. And then, okay, an important amendment was made in 1994 to SDBA after the Highland Towers tragedy. Now, actually, Highland Towers tragedy occurred 11th of December 1993. So what date is today? So it's almost to the month of the tragedy that occurred in Malaysia, one of the biggest building failure cases in the country. But besides Highland Towers, there are many more building failure cases. You can easily Google to find online. So what happened in 1994 after Highland Towers? More stringent controls over hillside development. So we have now guidelines for hill slope developments, for instance. Any developments that are proposed to take place on hill slopes, for instance, of certain gradients, need to follow certain rules, or some may not be allowed at all. Yeah. Period, because Highland Towers, if you, for non-Malaysians, if you look later on, the Highland Towers was apartment, an apartment development located on high grounds and hilly slope. A hill slope. So that's why after that, more attention was given to hill slope development, more stringent controls, and periodic inspections as well during construction and during occupation. So not only the local authority monitor during the construction, after occupation also, there's a provision now that requires periodic inspection by the local authority. So we shall have a look in the fourth section when we talk about, do we have that? I think that section 3, when we talk about the amendments of the Highland Towers. Another significant amendment was in 2007 now. What I told you before in other lectures, 2007 was an important year in development control, in building control in Malaysia, whereby the government tried to streamline development approval process, and also try to make things less bureaucratic, less red tapes for most apa nama tu, approvals needed at the local authority. So new building certification procedures in 2007. Now, why UBBL? What about UBBL? The subsidiary legislation. Why was UBBL enacted? It was established to standardize previously multiple bylaws and streamline plan approval. So again, in different parts of Malaysia at that time, before 1984, there were different building bylaws in each state or in each major city in Malaysia. Penang one different, and then KL one is different, JB one is different. So the government decided to streamline the bylaws, and they enacted the UBBL. What is UBBL? It specifies the material and construction standards of buildings in Malaysia. Okay, not only the construction standards, but also material to be used. Okay, so construction standards, for instance, what kind of square footage per occupant, for instance, or how many occupants per square footage, the other way around actually, how many occupants per square footage of the building, so things like that. Daylight, for instance, right, the windows, the opening, and so on. Okay, UBBL is read together with Act 133, whereby UBBL is detailed, whilst Act 133 contains only general provision. So Act 133 will state, okay, you need to have CCC. You have to have to you need to have new buildings to be certified under the CCC system. So how many steps, what kind of forms, those are contained in UBBL. Now, the similarity of both Act 133 and UBBL, the pre-occupancy building control up until the occupancy period, the occupancy stage, whereby the most significant overlap is in the matter of certification of newly completed buildings, CCC lah. Now, part 2, which is bylaws 3 to 29 of UBBL, regards building plan submission, whereby BL3. BL stands for bylaw. Okay, so in Malay is Undang-Undang Kecil 3, UK 3. So it's not section. So if we read X, we will read it as section 3, section 4, subsection 1, or whatever. But when we talk about bylaws, we refer the provisions as bylaw BL. BL3 stands for bylaw 3. Prior to construction, proposed building plan must obtain approval of the building department of the local authority. Now, the key word is local authority, but which unit is the building department at the local authority? Now, planning permission, remember, planning permission is under the local planning authority. It's at the planning department of the local authority. So all building matters go to the building departments. But it depends on the local authorities. Some of the local authorities, they call their building departments as units, building units. So it depends on the size, depend on where the local authorities are. But it's at the building punya part of the local authority. And all plans for building submitted to the local authority for approval in addition to the requirements of UBL shall facilitate the concurrent processing system implemented at the one-stop center. So must comply with the one-stop center requirements, how many sets and things like that, when to submit and things like that. What about BL5? BL5 states that the erection of a building shall be carried out under full-time supervision of a construction site supervisor who is accredited and certified by the CIDB, Construction Industry Development Board. So in Malaysia, there is an organization, or there is a board that who is in charge of training people in the construction industry. Not just training, whereby they will issue what they call green card and things like that. Not just training, but also they are also in charge of conducting research and development. For instance, in building materials, construction materials, and other things related to construction. Okay. Have you heard of IBS before? Industrialized building system. You know, the Lego building and the Lego parts of whereby you just connect the different building parts to speed up the construction process. Now, CIDB has come up with, I think, 2 so far, yeah, what they call IBS roadmap to promote IBS in Malaysia. That's just an example of their role, besides training construction professionals, yeah. Now, what about BL8? All building plans shall be deposited in triplicate or in as many copies as may be required by the local authority. So triplicate is the minimum, but it depends on the local authority requirement. Some bigger local authorities may require more more what you call copies of the documents of the plans. Now, who administers SDBA and UBBL? Administered by the local authority, especially. That's why I highlight local authority, but also under the state authority to some extent, especially when setting standards, building standards. The state authority also has a say. To a certain extent lah, but the one who implements the standards are the local authority lah. Local authorities. Now we have our friend there, Ministry of Housing and Local Government, who oversees the administration of SDBA and UBBL. So any issues, for instance, is the Ministry of Housing and Local Government who will pick up on the issue, and then do roadshows and if there's any proposed changes or amendments to the act, is under the purview of the Ministry of Housing and Local Government. And it's the building department at local authorities that implement building department at the local authorities that implements the building control aspect of SDBA and UBBL. So planning is under planning department, or LPA, local planning authority. Building control, the building plan approval is under the building department. But there's a difference there between building department and OSC. Both are different institutions or different departments. OSC is just the secretariat, if you may imagine, if you can imagine. Okay, secretariat. The one who the one who decides is the building department. Who scrutinize the details, come up with the conditions is the building department. Okay, OSC is just the secretariat. It's just the postman, middleman. Okay, OSC does not have the power to approve or to reject any applications. Now, comparison side by side, anatomy of SDBA and UBBL. Okay, you can see there, SDBA thicker, 131 sections divided into 8 parts. Okay, prelim, streets, drains. These one are streets, drains, back lanes, buildings. Now, one of the questions that I ask in your tutorial is, I think I ask you, why do we have these three things, streets, drainage, and buildings in one act? So I want you to think about it. You may not find the answer in anything that you read. Something that maybe you observe, or maybe you can think on your own. I think one of the questions that I asked you. Anyway, streets, drains, back lanes, buildings, and the miscellaneous, and the bylaws, repeals, and whatever, and whatnot at the back of the SDBA. And then UBBL, 9 parts. You have the prelim, submission of plans for approval, which we have covered before this. Space, light, and ventilation. Okay, again, the building standards to ensure the health of the occupants. Temporary works in connection with building operations, structural requirements, construction, fire. You see that fire, 2 separate parts. Okay, fire requirements, fire alarms, fire extinguishers. It shows how important it is for fire control. So this contains both active and passive firefighting punya features of buildings lah. You can see, quite interesting. Everything is interesting to me because you see, if we have skyscrapers, right? What kind of fire fighting control or firefighting features that we incorporate in Malaysia, for instance? what kind of fire resistance of our building materials currently in Malaysia, for instance, for high building. The one that's coming up is 118 stories. So if you can imagine the World Trade Center, how many stories there, and how long it took for the whole building to caught on fire and then to collapse. So quite interesting. And the fact that we have so many tall buildings in Malaysia, in other parts of the world. That's why I think this is quite important. And schedules, fees, forms, or the details on the material weight, roof fire, and new building certification. So this is the hint for your CCC, new building certification, which contains 21 forms. Now, what about the function of the local authority pertaining to building control? Now, the functions, the building control functions include to ensure the buildings are erected with structural soundness, as I said before, to prevent from building failures, to ensure that buildings are free from fire hazards. Okay, the two parts of the UBBL just now, fire hazards, to ensure that buildings are designed, built, and maintained free from any defects, nuisance, or danger to life and death. So one is about safety, and then this is about fire. This is about well-being. Nuisance or danger. Danger can be safety, but this one, nuisance. We don't want buildings to be constructed just to later on become nuisance, or some development to be approved, the building plan, just for some parts of the development to become nuisance to the occupants later on. We don't want that. So it's quite important for local authority to control these aspects of new buildings. So specifically regarding the building control just now, local authorities' functions or roles to approve planning permission and building plan. So planning permission is needed before you undertake any development on the land. Couple that with the building plan itself, needs to be approved as well. Okay, so planning permission to undertake development on the land, but building plan for the new building itself. Or for nowadays, if you can imagine, there are many more complex or sophisticated buildings, mixed developments, for instance, being submitted as one layout plan or building plan, master plan. Wow, kan? So quite challenging for the local authorities to deal with or to consider. Conduct on-site inspections on own initiative or in response to complaints. Again, just now, nuisance, or just to ensure that the building, the building under construction is safe. During construction itself. During construction or post-occupancy, both the local authorities have the duty there during construction and also post-occupation as well. Ensure that the safety of buildings exceeding 5 floors and aging, this one lah, I was telling you about, the post-occupancy. Exceeding 5 floors, aging 10 years from the date CCC are inspected every 10 years. So this is talking about the periodic inspection. Post Highland Towers, we realized that the buildings, after a certain number of years, due to wear and tear, due to many other factors that are unforeseen, maybe the changes in the site, itself, maybe the soil becomes weakened or whatever, so there needs to be a periodic inspection. So in this case, in Malaysia, we say within every 10 years, not 10 years, or within 10 years. So you may have the building inspection earlier, or, but must be within 10 years after that, 10, 10, 10. Issue CFO for development, which submitted building plans. Okay, so this is function of the local authority that is fast becoming obsolete, no longer relevant. Now, this CFO, system of certification of new buildings, was the old system prior to 2007, the 2007 amendment to SDBA. So any buildings approved before August, I think 12 August 2008, any approval before 2008 to prior, that is still not ongoing, that still hasn't received their certification, that has to be certified under the CFO system. And the certificate of fitness for occupation, CFO, is a certification system whereby it's the local authorities who issue the CFO, not the current system for new buildings under CCC system, that is under the PSP, the professionals who issue the certification for new buildings. So those are two very different systems. Under CFO, it's the responsibility of the local authority to issue the certificate. But for the CCC system, it's the responsibility of the PSP, the principal submitting person, or the professionals just now, to issue the certification. So two very different systems. The ways to submit are also different. Who issues the certificates are also different, and things like that. The problems are also different. CFO, very problematic. So it says that the approval before the coming into operation of the CCC system. So due to problems before, there were so many delays. So many delays under the old system of CFO. Some of the older buildings still haven't received their CFO. So it's still the responsibility of the local authorities to issue the CFO. But like I said, this is fast becoming obsolete and no longer relevant, because how many years have passed since the introduction of CCC? Now it's already 2020, so that's about 13 years ago that we replaced the CFO system with CCC. So in terms of PSP, what's the power, or how does the local authority control the PSP? What kind of controls does the local authority have under PSP? One is issue notice to the PSP, or there's a P missing here, principal submitting person, PSP. Notice to them to take action on any matter not in compliance with the provisions of the law and the technical conditions imposed in the planning permissions and also building plan. So again, whose responsibility is it to make sure that the building or the development is constructed according to the approved plans? It's the responsibility of the principal submitting person. So if there's any deviation from the approved plan, if it comes to the knowledge of the local authority that there is some deviation from the approved plans, they will issue notice. They will give notice to the PSP to rectify the situation. If you deviate, you rectify, maybe if you have erected a portion of the development or portion of the building in contradiction to the approved plan, you have to demolish and then develop or construct again according to the approved plans and specifications. The second one, issue notice to PSP to withhold the issuance of CCC until non-compliances have been rectified, fully rectified. Issue notice to PSP if a non-compliance occurs but not reported to the local authority. Again, non-compliance. Charge the professional in court and report to the professional board for any wrongdoing. So if found guilty, what will happen to the professional? What will happen to the architect, the engineer, the draftsman? Just three categories of PSP, right? Architects, engineer, and also draftsman. Okay, registered architect lah, registered engineer, and also draftsman just now, registered draftsman. What kind of actions can be taken if found guilty? They will be stripped of their license. Okay, they can no longer practice. They can no longer sign their drawings. Report. That's the I think the light punishment, instead of giving them harsher penalties such as jail, such as which in some cases is it's needed, not needed lah, is fair. Anyway, charge the parties who have provided false certification. So a warning to the PSPs not to for instance, abuse their power and issue CCC when they know that the building has not been completed yet. If you know, the name is Certificate of Completion and Compliance. So C, the completion part. If the building has not been completed, if a CCC has been issued, then false certification can be charged. Okay, as specified in UBBL, and report them to the respective regulatory bodies as well, their boards. So who, we've been mentioning PSP. So who is a PSP? So in order for us to understand who is a PSP, we have to know this first: qualified person. Qualified. So who is a qualified person? It is an architect, registered building draftsman, or engineer. Only 3 categories. Do we see any QS here? No. Do we see any valuers here? No. Do we see any land administrators here? No. So only architects, registered building draftsman. Now draftsman in the Malaysian punya definition or Malaysian context, any can we say architect, not architect lah, any person who are allowed, this, because it says here registered, right? Who are allowed because they have been registered to draw up until 2 stories, any residential buildings, if I'm not mistaken, only residential buildings, but I'm very sure about the 2 stories. That's the maximum height that they can draw. Okay, so that's the difference. Meaning that they are, can I say, mini architects? Mini architects, they can draw plans of the building, but for a limited type, limited number of stories. Okay, and also engineers. Okay, this is according to Building Law 2 of UBBL. So if this is the qualified person, we have understood that there's only 3 professions that can qualify for, that can be qualified persons. PSP, principal submitting person, is a qualified person above, see the 3 categories, a qualified person who submits building plans to the local authority for approval. So the architect, the registered building draftsman, the engineer who submits the building plans, the architect whose name you can find on the building plans, for instance, their chop and their signature, the sometimes not chop lah, sometimes even the address at the bottom of the, or at the top of the drawing, I don't know. So those people who submit, those qualified person who submit the building plans to local authority is the PSP, principal submitting person. Now, Building Law 258, requirements of compliance by the qualified person in event of building failure. So there are certain things that certain responsibilities that stay with the qualified person in terms of the building that they help to build, that they supervise until its completion. For instance, 258 sub 5, in the event of a building failure, the qualified person is always be held responsible, even though the plans and calculations have been approved by the local authority. So now you can see here clearly the local authority has somewhat shifted the liability to the qualified person or the principal submitting person just now, rather than accepting the liability. They are allowed under law to shift the liability to another person, to the PSP. Now, what are the areas outside PSP's purview? They are responsible over the building's technical issues only concerning health, safety, and essential services, but non-technical issues such as the Bumi Kota. Non-Malaysians, Bumi Putra Kota. Okay, if you learn Malaysian real estate, you somehow have to be familiar with this. Google. Okay, Bumi Putra Kota, low cost housing provision, okay, and contribution for public facilities fall outside the purview. So the PSPs are not responsible for non-technical issues such as Bumi Kota, low cost housing quota, the contribution for public facilities, all this. Okay, the owner of the proposed development who must negotiate and things like that. and still have to be resolved within the owner. I said here, the party responsible is the owner. Still has to be resolved between the owner and local authorities at the planning and building plans approval stage or via other mechanisms. Yeah. So this is the negotiation stage. Resolving the issue, the Bumiputra Kota and things like that. Okay. So who does this one are the planners normally. I'm not sure about the system in China, but in Malaysia, normally planners versus planners. So the planners of the planners who work with the developers, they will negotiate with the planners who work at the local authority. Advantages of UBBL: to establish uniformity of standards throughout Malaysia. Okay, to regulate again all the laws that we mentioned at the national level. Their aim is to 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 unif to set uniform standards, or to give some kind of harmony to the different prior legislation available in Malaysia before. Same lah, national land code and things like that. And later on, you will find out our environmental act in Malaysia, or environmental legislation. Then to regulate the design and construction, okay, of buildings, to save costs and expedite application, provide comprehensive section relating to structural fire precautions, specify eligibility of submitting person, their responsibilities, their duties. And last one, emphasizes the use of Malaysian standards. Now, before, in 1984, the original document was the original UBBL was heavily influenced by British standards. Because our architects in Malaysia, most of them, they receive their training in the UK. Same lah, planners in Malaysia, they receive their training mostly in the UK. So the planning, the building control in Malaysia, the design, heavily influenced by the UK. Okay. Weaknesses. So what about weaknesses of UBBL? Not entirely urban. Malaysia is not entirely urbanized. So the uniformity of application of standard tends to affect smaller urban areas. Okay, when you set, for instance, the what you call window, or the opening, the minimum opening. For shop houses in major cities. Compare that with smaller cities whereby the developers have less resources, for instance, kan? And things are not that polluted, for instance, are not that vital for them to observe the requirements. Better environmental quality in smaller towns, for instance, kan? So you don't need that kind of extra building standards. There, extra cost lah, extra building standards, extra cost. Constant improvements and innovation in building technologies at times will create conflicts with strict interpretation of certain bylaws. Okay, so UBBL, for instance, now we have the container house, kan? I remember that because one of my students did that for her thesis. Yeah, we wanted to find out how local authorities feel about container houses in Malaysia, because at one time, 5 years ago maybe, there's suddenly this interest in container houses in Malaysia because it's cheap, for instance. That's one thing, cheap. So we want to know lah. We went to my student went to one or two local authorities. We found out that they don't know, they don't have any guidelines, and they were quite uncertain on how to process the application, for instance, or even the container houses need any planning permission or not, for instance. Yeah, because it's quite new, constant improvements and innovations, for instance. Yeah. So that's just an example. IBS also at one time during the introduction of IBS in Malaysia. Okay, again, local authority personnel may not have the same kind of cutting edge knowledge of the technology. May not have the knowledge of the cutting edge technology compared to the developers who have all these new graduates, new people with interesting ideas. Yeah, so conflicts lah. Difficulty in interpretation of bylaws, monitoring its implementation and reviewing its effectiveness. Now, law books are there, it's black and white, but the law provisions or the legal provisions need to be interpreted by whom? By human beings. So the way people interpret, when you read something, one person's interpretation may be different from another. So that's why sometimes, remember when I gave you the example of the word shall? So one person may think of the word shall as you have the flexibility. You shall do this. You shall, meaning you can if you want, or you can if you don't want. But another interpretation of shall is thou shalt not kill. Kan? You must not. So, two different interpretations. So again, interpretation of bylaws, monitoring its implementation and reviewing. It's quite normal. Not in Malaysia. This is a very common problem everywhere, because the written text needs to be interpreted. The written text need to be understood. Again, as I said, who interprets, who understands? Humans. So we come with different education, different upbringing, for instance. So different people have different interpretations. Okay, now we come to the functions of SDBA. Yeah, functions of SDBA. Now, you can see here there are 4 functions of Act 1333. Okay. The thing that I want to tell you, or I want you to focus on, not focus lah, tell you lah, about the 4 functions. You can see they have different colors. Okay, they have different colors. 4 functions: red, green, purple, and orange. Okay, the first one is clarifying the duties of local authorities and property professionals. Okay. The second one, specifying the local authority's power over building control. So it's actually the second one that is most substantial compared to the other functions. So we have clarifying the duties of local authorities. So what are the scopes of responsibilities are under local authorities? What are the scopes under property professionals? That's the first one. Second one, the local authority's power over building control. So this is quite substantial. The most significant portion of the function of Act 133. Then we have the building certification, CCC. Okay, Act 133 also outlines the requirements. The requirements are not need the requirements for building certification. Okay, who issues things like that, and what are the penalties for instance just now for issuing false information, not issuing, for providing false information, for issuing CCC that should not have been issued in the first place. And then the fourth function is clarifying the local authorities' enforcement power in building law. And as I said so many times before, without the power or without the enforcement power given to the local authority in such acts, for instance, in this one is SDBA, but we have talked before the powers under local government act, Act 171. Without the act specifying the powers, the responsibilities, and if the local authority acts beyond what is given, what authority is given to them, what powers given to them, the local authorities may be construed as having acted ultra vires, and the action may be considered as illegal. Null and void is fine. If a statement, if a policy is null and void, that's fine. Null and void means there's no meaning. But if it's illegal, then it can create other issues lah. Okay, now the first one, clarifying the duties of local authorities versus professionals. Okay, the first one, so what are the things under local authority? What are the things under professionals? So as to avoid overlaps, that's the first one, and to clarify the responsibilities of each party, so that each party are clear. Each party is clear about their roles, their functions, their responsibilities in terms of building control or building construction. PSPs are responsible to ensure that the design and construction of the new building comply with building standards. Okay, and the system will be further discussed below, the CCC system. The local authorities' role focuses on monitoring and enforcement of building control. So PSP is the one who undertakes proper construction and then certification of new buildings. Local authority monitors. Local authority, when there's deviation, when there's any discrepancies between what was approved and what's being constructed by the PSP, they are the ones who enforce, who issues notices to rectify the deviations, to rectify the what you call the differences between what was approved and what's actually being constructed. So monitoring enforcement lies with the local authority. The carrying out of proper construction of the certification later on is under PSPs. Now, this is what I said. You can see here, local authorities' power over building control. This is only number one. Okay. I think there's 6 of powers given to the local authority over building control. The first one is building plan approval. So if you want to construct a new, basically what this slide says, if you want to construct a new building, you have to prepare building plans and you have to submit the building plans to the local authority for their approval. Again, if we go back to the lecture on planning, town planning, if you want to develop the land, you have to prepare the LCP, the development, the proposed development report, kan? The proposed development report, and then you submit to the local authority for their consideration. The local authority will look at the or will refer to the development plans and then make their decision. So in this particular case, the building plan approval, the PSP will prepare the drawings of the proposed building. I think 6 types of plans needed to be submitted. The layout, the site, the key, the section plan, the whatever plan, 6 types. Then the building department, building department will refer to the UBBL to see if the calculations are correct, if the standards are being followed by the PSPs, by the architects, the draftsmen, and also the engineers just now. Now, so the first power, building plan approval, section 70, 70 sub 1, written permission should be obtained. So this is clear, should be obtained. There's nothing that ambiguous or nothing that is flexible about this statement. Should be obtained from the local authority prior to erecting any building on the land. Section 70 sub 2, any person who intends to erect any building must submit to the local authority plans and specifications that are in accordance with Act 133 and at UBBL accordingly. So plans and specifications. So plans, drawings, specifications, written statements. Okay, 2 things. They must submit the plans, the drawings, the specification, the written statements. Section 70 sub 16, what is the definition of erecting a building? It's building a new building, obviously. You want to construct a new building, erecting a building. But also renovation, extension, demolition, addition, alteration, and conversion of an existing building. So the definition of erecting a building is much wider than what we imagine. So that's why it's important to read the definition sections at the beginning of any acts before you can go and interpret or read any provisions under the act. Okay, so in this particular case, if you have a terrace house, for instance, you want to enlarge your house, you want to have a bigger kitchen, kan? So you extend the kitchen, right? Extension. So your extension needs to be approved by the local authority. Before you go and knock down any walls and construct any new walls, you need to obtain their permission for any extensions at the back, in front. You want to add a floor, for instance, an attic, kan? Addition. to your double-story terrace house. You say what you maybe you think, oh, I want to have an attic for a study to make it into a study, to make it into a gym whatever. So any additional floors need to be approved by the local authority first, by way of you submit the building plan and also specifications. You to meaning the just now lah, the PSP. But in major cities in Malaysia, KL for instance lah, an obvious local authority, DBKL kan, the city hall of Kuala Lumpur. Now DBKL, because this is so what do you call it, so normal, so yeah, for us Malaysians, if the first thing that we do when we buy a new house, I don't know about things nowadays, but what used to be was we extend the house, extend the kitchen, extend the living room to make it fully built when we move into a new house. So DBKL anticipates this. So what they do is they have what they call pre-approved plans, because terrace house, what can you do with terrace house? The land is rectangle, right? So there's no way you can build beyond your land. So they have come up with pre-approved plans. For instance, Plan A, Plan B, Plan C. Plan A is just the extension in front. Plan B is an extension at the kitchen, at the back. Plan C is front and back. So you just buy. You go to the BKL, for instance. You buy. You say that I want to extend my kitchen. You pay for Plan B, and then that's it. You obtain your approval from the local authority. So that's how the local authorities they react to the socio-economic signals around them lah. So when they know that a lot of people renovate their house or extend their house, and a lot of people do not obtain prior permissions before extending their house. So what's the best thing that they can do? Pemutihan lah, to legalize the situation. They come up with this idea of pre-approved plans, and then they sell over the counter lah. You go there and then you make an application, you pay, that's it. You obtain your extension approval from the local authority. Now, Section 70 sub 4, local authority may attach conditions for the approval of the proposed building plans. Together, same with planning permission before, conditions can be attached together with the approval of proposed building plan. 1, 2, 3, 4, 5. Sorry, 5. Yeah, 5 plans: site, key, floor plans, building sections, elevation. So 5 kinds of drawings lah. Building plans include this: the site plan, key plans, floor plans, building sections, and also elevations. For my undergraduates, I normally show in class, but not for you, okay, master students. Now, what about this one? Local authorities, second one, power to supervise during construction. So this is the power, the power for building control pre-construction, at the planning stage, when the owner of the building is just thinking about developing or thinking about constructing on the site. So this building plan approval when not really for extension. So this is for existing building kan. So but mostly for new development lah. Okay, but this one during construction, the power. After Highland Towers, more safety provisions added. See here, the alphabets after Section 70. So this means these are additions to Section 70. So A, section 70A, 70B, 70C, 70D. The first one, 70A. Earthworks must get local authorities written consent, and local authority can stop works that may pose danger. So earthworks mean, the leveling, the cutting of hills, filling. So those are earthworks. Okay, for the foundation lah, kan. The first step of building anything is you have to get the foundation sorted out, kan. So any earthwork, you have to level the land, you have to fill any low lying lands. Earthworks must obtain local authorities written consent before you can even bring a tractor, bring a bulldozer to the site and start leveling. You need to obtain the earthworks permission, permission for earthworks, written one. And local authority can stop works that may pose danger. Okay, but here in the bracket, excluding earthworks by government, because again, the government is acting. We assume that the government acts on behalf of the public or in the public interest, kan? So it is unthinkable that that any works by the government will endanger the public, because that will not be in public interest. So that's why lah, excluding earthworks by government. So governments, they have what they call the green lane punya approvals, whereby some of the works, infrastructure work, for instance, they need to get things done, kan? So to avoid delays, okay, for earthworks, government may not apply for permissions. Then Section 70B, if any irregular changes occur to land during construction which was outside the approved plan, local authority may issue review order of the building, its foundation, and also the surroundings. So review order. The construction is underway, but maybe when the local authority officers, they normally do their rounds, they go and they do site inspection, or they just they do their rounds lah, inspections lah, that's what they do. So maybe the local authority officers, they notice what do you call that, they notice streams, new streams running from the site. So they can suspect that there's a problem with the underground soil, for instance. So they may issue review order. So it's not only the local authority officers that may notice any irregular changes. It also can be reported by neighbors lah, during the construction, where if you have if you are living in an area, there's a new construction going next door, and you notice, what you can not avalanche, you can notice landslips, tanah runtuh lah, yang kecil-kecil, tanah runtuh, or the ni, then can report to the local authority. Local authority can take action. This one including asking for a review of the development in terms of the building, the foundation, and also surroundings, the surrounding lands. And who does the review? The review is done by qualified person not connected to the original approved plans. So any other architects, draftsmen, or engineers are normally architects and engineers. Section 70 C, local authority can revoke approval upon contravention of 70B. If you fail to do the review just now, the local authority can revoke the approval of the building plan. 70D, local authority can take samples of building material at any time during construction. Spot check. Can take any samples, go back to the labs, and then do tests on the building material. Okay, the third power, of the local authority is the power to review completed building. So this is when the post-occupancy comes in. Upon approval of building plan, the applicant has 12 months to commence construction, or the development order is automatically revoked. Now, development order is also the name for planning permission, but development order is the term used in KL. Same thing, development order, planning permission, which is what you obtain from the LPA, the local planning authority. Now, section 85A states that local authority can require for periodic inspections of the building. First inspection 10 years after the CCC date, and thereafter within 10 years of the last inspection. So maximum is 10 years, 10 years, 10 years, but you can make the inspection earlier than the 10th year. Why? As I said before, some changes may have occurred on the building. For instance, the wear and tear of the materials themselves, wear and tear. Also, the site changes in the soil condition, for instance. Okay, other factors as well. Maybe the building. For instance, low-cost housing, mentality of the occupants or residents there can cause the wear and tear to occur to occur at a more rapid speed compared to conventional housing lah, market housing lah. So that's why they need to check, or they need to monitor if the buildings are still okay or not. So regular or periodic inspections are needed post occupancy. What about the fourth one? Nuisance control. Nuisance. Remember, we go back to our Local Government Act. Local Government Act 1976, Act 171. Nuisance control or nuisance abatement is the duty of the local authority to take care, or not take care, to get rid of any nuisance within the local authority area. So it is the responsibility of the local authority under Act 171 to get rid, or to handle the nuisance within their local authority area. And this provision regarding the responsibility of the local authority pertaining nuisance is repeated under under the SDBA, Act 133. But actually, Act 133 comes first before LGA, Local Government Act. So 133 comes before 171. So actually, it's the provision under 171 that repeats the provision under Street Drainage and Building Act, Act 133. But the same thing. So this appears in at least two major acts regarding local authority. So nuisance control, sections 86 to 90, pertaining to nuisance caused by a building, because this is a building law. Okay, caused by a building. Local authority may order the building occupiers or owner to abate the nuisance. Abate means to stop. And or carry out remedial actions to rectify the problem just now, to make better the nuisance condition, which will be charged to the occupier or owner. So either the occupiers themselves abate the nuisance, or the local authority may abate the nuisance, and they carry out the repair works or the remedial actions, and then claim from the owners. But whatever it is, the nuisance need to be stopped. That's their responsibility. Local authority may apply from the magistrate's court for nuisance order, which may be abatement order. It may also be prohibition order. Abatement or prohibition or both. So what is abatement order? It's for the occupier to stop the nuisance. This one, example, if you bring, this is quite a normal example, animals to the building. You keep animals in the building, for instance. So the extreme case was the foreigner or foreign family who kept goats or a goat in their apartment. Nuisance. That is actually a nuisance related to a building, because there is sound pollution, there is smell pollution, and also the droppings may also interfere with the building material in the long term, kan? So it's not an isolated case, the keeping of animals and how that can give rise to nuisance. I can recall, there is a High Court case pertaining to nuisance coming from goat sheds. Goat sheds meaning the sheds where they keep their goats. So this, I think it's a Perlis case. It's a Perlis case. Perlis case. There were complaints by the neighbors regarding the smell, the sound made by the goats. The goats were kept in, it's not a residential area, it's a kampong area, it's an agricultural area, kan, a rural area. But the thing is, there were neighbors living there. Okay, and the neighbors made a complaint, and then made a complaint, and then I think the land administrator sued the goat owners in court, and of course the land administrator won, because nuisance is a responsibility of the local authority to stop it, even though there's objection from the goat owners when they say that, we are living in a rural area, that's not a strong enough defense. They had to stop the nuisance that they created, abate, this one, abate, to stop lah. Abatement order, stop the nuisance. Prohibition order, occupier to prevent from reoccurrence, from doing it again. Closing order, the house will be declared as unfit for human habitation. And afterwards, if it is so bad, a demolition order may be obtained against the owner, and then the house may, or the building may be demolished. The fifth power is bylaws, section 133 of SDBA. If you see section, it refers to SDBA or Act 133. But if you see BL, that refers to UBBL lah. Okay, anyway, section 133 of SDBA, look, the state authority can make building bylaws. So for instance, in KL, you have the Building Federal Territory of Kuala Lumpur Bylaws 1985, enforced alongside Act 133 and also UBBL. So you have in KL a 3-tier building control. Okay, so that's that could be a cause for concern lah, or a cause for complaint among developers, because now instead of having two laws that they need to comply with, you have a third one. So the developers tend to talk about compliance cost here when they complain about the legal framework. The sixth power is prevent obstruction of public places, spaces. Okay, this is quite, everything is interesting. Sorry lah, I like law. I don't know about you, but the way to like law is to read on your own, not just to come to class and listen to the lecturer, because sometimes it's quite boring. But the lectures can give you can trigger something lah, something in you that makes you want to go out and find out more about the topic. Anyway, this one. 6, prevent obstruction of public spaces, related to the Ao Kian Ho case that I provided on Spectrum. Okay, now it is the duty of the local authority to prevent obstruction of public spaces. So this was the argument used against what you call a boom gate in this Ao Kian Ho's case. We can see later. I will discuss about this later on. But whether in this case, the boom gate is construed or is considered obstruction or not. There's two arguments there: obstruction and also nuisance lah. So I will later on see here. Now, section 46 here prohibits any obstruction in any public spaces, such as building any wall, fence, rail, post, or covers open drains. So in any public spaces, for instance, you have public spaces, building any wall, fence, upper public spaces. Public spaces, anything that is not private property is public spaces. Okay, that's the easiest definition of public spaces. So if there's any obstruction there, for instance, walls that prevent people from going to the other side of the public space, or fence, or rails, or posts, or covers open drains, those can be considered obstructions, and the local authority has to remove the obstruction. The local authority may fine the offender or remove all the obstructions, with the removal expenses being borne by the offender. However, temporary obstructions are okay lah. Temporary obstructions on festival occasions is considered fine because it's only temporary. It does not it will cause an inconvenience, but only a temporary inconvenience. Now, the Ao Kian Ho case, okay, Ao Kian Ho versus the Persatuan Penduduk di Villa Equestrian. Persatuan Penduduk is Residents Association. This case went all the way up to the federal court. So it's not, don't play. It's not a minor case, okay? Because this was a test case against gated and guarded communities in Malaysia, and it was talked about. This case, the what do you call, the precedent that was set by this case was, if the boom gates, if the guardhouse were approved as part of the building plan just now, then it's not an obstruction, and the local authority can the local authority is not mandated to remove the boom gate and the guardhouse, basically, essentially lah. So it's not under section 46 obstruction. Okay, and also in the federal court, the judge had to balance. The judges, they tried to find a balance between the obstruction being a nuisance and also public interest, which is why the boom gate was boom gates, two, one at front, one at the back of the equestrian, the villa equestrian. Why the boom gates were constructed in the first place? It's for the security of the residents. So in the interest of security, uh, the boom gates are not considered as obstructions or nuisance. So you can have a look at the case that I uploaded. It's not a judgment per se, so it's not that boring. It's a press release by the Attorney General Chambers. Quite short. So have a look. Read the Aukian Ho case. Sorry, the I put there the Boomgate case. Have a look at that one. Quite interesting. Okay, everything is interesting. Anyway, build. Okay, now the power. Sorry, where were we at? The certification. Yeah, the functions. We are here at the purple. Yeah, function of local authorities is in the matter of building certification. So in 2007, Act 133 improved the system of certifying newly completed buildings. As I said before, the system was CFO. Now it's CCC. The Certificate of Completion and Compliance requires the principal submitting person or PSP to monitor and certify. So two things, you must monitor, then you must certify the building from its construction to its completion. Monitor what? Monitor that the building is being constructed according to the approved plans and specifications. Certify what? Certify the same thing lah. The building has been constructed according to the approved plans and the specifications. But at the same time, to monitor, to certify that the building has been completed. Okay. And the responsibilities of the PSPs include submitting building plans for approval by local authorities, supervising and the erection and completion of the building in conformity with the approved plans and requirements of the provisions of acts or bylaws, ensuring all technical conditions. Again, all technical conditions, the non-technical conditions are not their responsibility to ensure that these are followed with or complied with. Ensuring that the building is safe and fit for occupation is also the PSP's responsibility if there's any case of building failure. And worst case scenario is structural failure. The building collapses. Oh, that's it. In the case of structural failure, the liability stays with the PSP for life. The life of the building, or if the PSP dies, whichever comes first, lah. So the liability is for life. Warranty on their name is for life in case of total building failure, structural failure. That's why architects get paid so much. Anyway, enforcement power, the last one, the last function of the local authority. Some sanctions or some penalties under Act 133, 7011, illegal building alteration. Fine not more than 1,000, demolition. 70 sub 12, unauthorized change of original use, a fine of not more than 1,000 plus not more than 100 per day. The offence was continued after breach notice was served. Then what else? Section 71, penalty for building and earthwork failure. That's it. Some of the examples of the sanctions of the penalties that the local authority that the Act 133 can impose. On the owners or the PSPs. Ada lagi 6, I think. Yeah. 1, 2, 3, yeah, 6, betul, 6. Now, Section 72, the local authority can demolish or remove unauthorized building. At least 30, how? They come there to your site with a bulldozer. They can bulldoze the unauthorized buildings, but then before doing that, at least 30 days notice should be given to occupants of the building, requiring them to vacate the building. Once you come to UM, I will show you in front of UM, this one, Section 72 at play. There's a restaurant in front of the KL gate that has been in the news for quite some time because of this, still operating until now. Anyway, Section 73, the sanction of letting and sale of unauthorized building, which is imprisonment. Letting this one, okay, for estate agents, for building owners, letting and selling unauthorized building can get a jail sentence, maximum 2 years, or fine, maximum 10,000. So it's quite substantial. You don't want a jail sentence. Okay. Unauthorized buildings mean buildings that that are built without the building plans being approved. So salah. There's an interesting case whereby a factory was built illegally and the factory was let. The whole factory lah was let, and then I think like in this case the factory was let, the tenant didn't pay, the landlord tried to sue, claim for the unpaid rental. What did the court find? The court found that there's no contract between them because the subject of the contract is the illegal building. It cannot be it cannot be a subject matter of a contract. So there's no contract, meaning the tenant who has been staying there could stay there for free. He's not a squat because the building is illegal, so there's no contract. So the landlord cannot ask for the rental because there's no contract, no rental. So that's it lah. Nothing to sue, no basis to argue the case in court lah. So basically, and then if the local authority finds out this one lah, letting the illegal factory just now can bring a jail sentence, imprisonment maximum 2 years, fine maximum 10,000. Section 42 sub 1, written approval from local authority must be obtained to place. This is when you are doing your construction, placing the building materials. When you place your building materials, your sand, your bricks, whatever, you need to obtain written approval from the local authority as well. So when you the construction material need to the place where you store them, you need to obtain written approval. So you have a sanction here for failing to, if you fail to observe this provision or this requirement. So the third one, building control, we are going to discuss now the building plan approval process and also CCC. Now, don't worry, building plan approval is only one slide. Okay, 2 slides. Now, this is just an explanation of where to submit your building plan. You submit to the one-stop center, the postman just now, the secretariat. They will process. They will not decide. They just process the application. So where can you find the OSC? It's located at all local authorities. These semua local authorities, last count was 104 OSC. So meaning some local authorities haven't got OSC yet, walaupun you perlu ada, ataupun maybe they discount the ones in Sabah Sarawak maybe, but the figure I got was 104 so far OSCs. Anyway, strengthened in 2007 to streamline development approval process. The good thing about the streamlining of the development approval process is the cutting short the approval period from, it could take up to 2 years before actually, before the system. Now within months, within days. They say 60 days or whatever, but can be done very quickly compared to the last time. And the OSC's function is to process 4 types of applications. Before undertaking any development, you should know that there's 4 types of approvals that need to be obtained. One is the land matters, the national land code that we discussed before, the conversion, amalgamation, subdivision, what else? The other one, the surrender and re-alienation, all those. So that's the first type of approval, land matters. The second one is planning permission. We also have learned this last week in our TCPA lecture, planning permission. The third one is what we're learning now, building plan approval. And the fourth one that I mentioned earlier, earthwork plan, needs to obtain approval first, and road and drainage plan. So these two. We are not going to touch this because it's too technical lah. But 4 types of applications need to be obtained or need to be processed, need to be obtained by the owner or the developer, but need to be processed by the OSC. Okay. Acts as the secretariat, postman, merely accepts and processes the planning permission, building plan application, and upon acceptance of documents, the OSC will forward to the OSC committee members, chaired by the local authority president. So that's their duty. They receive the triplicate just now and the process. They will make copies and then they will send one copy to local authority president, the mayor just now. Yes, then the council members and all heads of town planning or the land office, heads of technical agencies. Remember, Mia said 14, she said, kan? So you can count lah, how many sets of applications need to be prepared by the OSC and need to be what do you call it? Need to be followed up by them later on. Okay, process. One slide. Beginning with the applicant submitting completed documents to where? To the OSC, and then OSC will then besides the local authority president or the mayor, they will also forward to the planning unit or the planning head, planning department head, also technical departments. Examples of which the Fire and Rescue Services Malaysia, Communication Multimedia, the Building Department, the Engineering Department, the DID, this one is JPS, DID, in the water, and so on. These are just examples of the technical departments. Then, upon obtaining their feedbacks, the OSC will collect their feedbacks, okay? Then the OSC committee will call for a meeting. Decide in the meeting. OSC will then submit the result or the discussion, the notes in the meeting or the minutes of the meeting will be forwarded to the building department. Building department will then decide, will give the decision. Then upon getting it, so this one we assume that the applicant was granted the building plan approval, must construct within 12 months of approval. Otherwise, the approval will lapse. This one lah, approval will lapse after 12 months if construction is not commenced. Okay. Now, what about CCC, the second type of certification just now? The previous system of building certification under CFO, Certificate of Fitness for Occupation, was hampered by delays. The main problem was this one, delays. The secondary problem or the less significant problem was this one, because of the fact that the local authorities at that time, also now, they lack qualified personnels who are able to process the certificates quickly lah. Not enough, not enough manpower, and sometimes not enough training as well. 2007, CFO was replaced with the CCC again. The OSC just now was the product of the 2007 streamlining of the development approval process. Now, CFO was replaced by CCC. So all references to CFO in the SDBA and UBBL has been replaced with CFO mutatis mutandis. If you open up any new SDBA that you purchase lah, not AGC, the text one, the book one. If you go to MPH, you buy the SDBA. Sometimes you can still find CFO inside the inside the act. But all reference to makna mutatis mutandis has been replaced, and all reference, anything inferred is also replaced. Maknanya you may find CFO, but CFO tu refers to CCC. Faham tak? Mutatis mutandis means wholly. Semua tu ditukarkan automatically. Mutatis mutandis. Then CCC is a certification that the building has been built according to the approved plan and law and fit to be occupied. Okay, the new building just now. Issued by the PSP. Again, the difference between CFO and CCC, this one is issued by the local authority. This one is issued by the PSP. And CCC is required for the, I said April lah, I said August. 12 April 2008, that was the date. 12 April onwards, 12 April 2008 onwards, the system is CCC for any buildings approved after that date. Any buildings approved before that date, they still fall under CFO system. And here, under the CCC system, the local authority plays a supervisory role rather than the party that issues the certificate. Now, the procedure, okay, construction stage is monitored. And remember the hint earlier on, 21 building components. Okay, the construction stage is monitored, yes, but how? At 21 stages. Okay, 21 building components, starting from earthworks to finally landscape. So you can see there's a progression from when you want to start building on the site until the building or development has been constructed. You just want to beautify, you want to enhance the aesthetics of the new development landscape, through landscape. Each component needs to be certified using specific forms indicating that the building component has complied building law requirements. And after the 21 components have been completed, the PSP will issue CCC under the bylaw 25. So BL 25 means that after the 21 components have been completed, you can issue the CCC. And these are the 21 components. You can see that this sets out the progression of the development or of the construction from earthworks until landscape. So you can see here it goes there's an order of things. After earthworks, you setting out foundation until finally dah siap semua tu, the building dah siap, all the mechanicals dah siap, road drainage, street lighting, and finally the landscape. So you can see here who's in charge of this one. Professional. Now here, roles and responsibilities of PSP in CCC: to submit and also to monitor as well. Two things. Submit what? Building plan to the local authority for approval using form A lah if you want to know. Okay, submit the building plan and also other plans. 5 types of plans. Okay, building, key layout, site, and the other one section. Section plan. Notice for the resumption of work through form B to so the notice must submit also notice for the resumption of work via form B to whom? To where? To the local authority, and also submit CCC to owner or developer and a copy of the certificate to the local authority and the relevant professional board. So 3 different submissions must be made with regard to CCC. 1 is to the owner/developer. 2, to the local authority for their files. At the local authorities, they have files on each development, and they will they will keep the CCC inside the files. Also important for strata later on. CCC. And also the last one, the relevant professional board. So if the architect, they will send to the Lembaga Arkitek Malaysia. There's no English equivalent. The Board of Architects Malaysia. More popularly known by their Malay name, which is Lembaga Arkitek Malaysia, which is not the same as Persatuan Arkitek Malaysia. Two different things. So LAM is the lembaga, LAM is the board, PAM is the society saja, is the secondary one. So if they want to get their registration, they get it from the LAM, LAM, Lembaga Arkitek Malaysia, the Board of Architects. For engineers, obtained from BOE lah, Board of Engineers. Yeah. What about monitoring? For submission, the first row, the second row is monitoring. Inform local authority through form B of construction operation. Supervise construction works, ensure compliance, report and explain the reasons for non-compliance. Okay, so you see here the what you call the elements of monitoring is quite serious. It's quite significant for the PSPs to follow, to carry to carry through lah. Ensure G forms just now, the 21 components too, the G forms are duly completed and deposit copies of all said forms to the local authority and professional board. Ensure that the rectification of non-compliances in case of any diversion or any deviances from the approved plan and also specifications, they need to ensure that the rectification of non-compliances during construction are complied with before using the CCC. I cannot just ignore the notice of the non-compliance and then issue CCC. That is totally against the provisions under SDBA. Why is it so important to have the CCC, the Certificate of Completion and Compliance? Important, yeah lah. We say that it certifies that the building is safe. Yes, but we're talking about the technical side. Why is it important technically? It precedes the delivery of vacant possession. We've heard that before, right? When a building is completed, you need to handle it over to the developer, the PSP just now. Sorry, the construction part must hand it over to the owner. Also, the developer needs to hand it over to the purchaser. So the handing over of the newly completed building is known as the delivery of vacant possession. So that's a specific legal jargon or legal term that is known colloquially as, in Malay, serah kunci. You give the key. Kan? Colloquially tu maknanya secara informal lah. So serah kunci sama dengan serahan milikan kosong. When you give the key to the new development, you deliver the vacant possession. So vacant possession here means that the property is free, not just vacant as in physically nothing in the property or nothing else. No furniture. No, that's not what it means. Vacant possession means that the property or the land or the title is free from encumbrances. No caveats, for instance. No charge, for instance. We've learned this before. No charge, no caveats, nothing. And nothing that can burden encumbrance to burden lah, that can burden the title. Okay, the title is clean. Okay, so CCC precedes the delivery of vacant possession. So it's a prerequisite of vacant possession, delivery of vacant possession. That's why it's so important. And is one of the determinants of the commencement of the defect liability period. So CCC precedes is the prerequisite of delivery of vacant possession, and also one of the things that we look for when we want to count the defect liability period. Defect liability period is like a warranty period for new buildings. If you buy a watch, if you buy a laptop, if you buy a car, there is a warranty period, right? Same thing with buying a new building. But anyway, that's another topic lah. New building, whether you are covered under the LP or not, another topic. But we have the housing law in Malaysia that specifies for new residential property, okay, the defect liability period is 24 months, 2 years. 2 years. Defect liability period for other types depends on the contract. So if you buy a house from an owner, that is not a new residential property. That is considered, that falls under the second type of DLP. It depends on the contract. You may not even have a defect liability period if the contract between you and the seller does not specify any such defect liability period. Only contracts drawn under the Housing Development Act contains this provision in Malaysia. So Housing Development Act, we're going to learn next 2 weeks. The date of the issuance of CCC will be important in the case of any dispute regarding who is responsible to rectify building defects, because this one, the clock starts ticking once the CCC is issued, once the delivery of vacant possession is given, because the LP is 24 months 24 months from the date of the CCC or the date of issuance of the delivery of vacant possession, 24 months, whichever comes earlier. So that's the how they calculate the 24 months. So it's very important to have to know or to what you call it, to know the CCC date, because the longer the CCC date means if you are given the vacant possession earlier, the clock starts ticking, the 24 months starts ticking from that point rather than waiting for your CCC. But the thing is, in theory, you need to have the CCC before you can deliver the vacant possession. In real life, sometimes you get the keys first before the CCC is issued due to delays or whatever. So theory is not the same as practice. So that's why it's very important, okay, theoretically to know the date of the CCC, because that determines when you get the vacant possession, and then the clock starts ticking, whichever comes first lah, between the date of CCC or the date of the delivery of vacant possession. For new housing construction, okay, delivery to the purchaser of the vacant possession for landed houses must be made within 24 months. And strata residential units within 34 months. So this one is talking about the delivery of vacant possession, not the CCC. Okay, delivery within 24 months or 36 months of the signing of the sale and purchase agreement. Okay. So when can CCC be issued? Okay, when? When, according to bylaw 25, bylaw 25 is the bylaw that states that CCC may be issued, but it also states the conditions when you can issue the CCC. When all technical conditions imposed by the local authority have been satisfactorily complied with, technical conditions such as the open space, things like that, enhanced security of the site, things like having a retaining wall, for instance. The retaining wall have been built, for instance, right? When forms G1 to G21 in respect of state certification, the components just now, building components, as set out in the second schedule, have been duly certified and received by him, by the PSP. When all the essential services have been provided, these are the examples of the essential services. And finally, when the PSP certifies in Form F, so besides, after getting the Forms G1, G21, okay, he will certify in Form F that he has supervised the erection and completion of the building, and that to the best of his knowledge and belief, the building has been constructed and completed in accordance with Act 133, the UBBL and approved plans. So it's not just words. It's not just words. This sets his liability, because here he admits or he signs on the statement that he knows that the building has been constructed and completed according to building laws. So it's his written acknowledgement, so that can bind him later on. So this is what Form F looks like, the certificate of completion and compliance, date, to whom I hereby issue the certificate. This one lah, I certify that I have supervised. So this is standard, yeah, and he will sign here. Right. So, okay, last part of the lecture. We are going to talk about Highland Towers and the local authorities' liability for building failures. Now, some facts of the Highland Towers case, but I would encourage you, if not, go Google the news or the papers, that there have been papers and written on this. What you can do is you go to YouTube. You can easily find so many videos, on Highland Towers. Now, comprised 3 tower blocks of 12 stories high, built from 1975 to 1978, so a long time ago. So this was before UBBL, UBBL 1984, right? And also the SDBA at that time 1974. So very at the very young stage, early stage of the SDBA as well. So we need to establish this, because this sets the context the context of the construction of the Highland Towers. It was constructed during the time when the SDBA has just been implemented a few years, okay, throughout 1975 to 1978. So due to the development of the area, a stream which is known in the court as the East Stream, there's no name for the stream, but it's known as the East Stream, okay, it was diverted into a drain that ran across the slope behind the Highland Towers. So there was a stream diversion. This is also a material fact of the case because there have been negligence cases by local authorities in the UK that our courts used as precedent to help them decide on this one, if there's a negligence or not in the part of the local authority when it comes to diversion of streams. Anyway, the drainage system was inadequately built, only 10% built but certified complete by the engineer. Again, incomplete development but certified complete. Okay, and the drainage system was considered part of the development, part of the construction. Okay, see the G form just now, drains, one of the components that need to be certified complete and also built according to the approved plan and certification. And Malaysia's monsoon season is at the end of the year, November, December, at this time of the year, December, yeah. Monsoon season, eventually the continuous rain overwhelmed the incomplete drainage system, which was only 10% built. And at the same time, remember, the stream was diverted. There was no longer a natural path that the water can flow. Then it has to go through, or it has to run in the drain, in the planned drain, but the drain was not completed. On 11 December 1993, the poorly constructed retaining walls gave way to the force of some 150,000 cubic meters of mud, which is the same as the weight of 200 Boeing 747 airplanes. So you can see the underground land turns to mud, turns to liquid. So that's why the liquid, because it was situated on high grounds, and gravity, the law of gravity dictates that the liquid has to flow down, right? So there was underground land movement that knocks down the foundation of the foundation of Tower 1 or Block A, they call it, yeah. And Block 1, Tower A, at 1:30 p.m. Okay, midday, Block 1 structural foundation failed and the building collapsed, and there were 48 deaths. So just some context as well. Okay, this is the Kuala Lumpur City Centre, the KLCC lah, the building lah. The Twin Towers, everything is here. KLCC is here, yeah. This is where the Highland Towers used to still stands lah. Two of the three buildings still stands. So this is Highland Towers. This is KLCC. Quite near, actually, just a few kilometers. You can see. So to bring home the fact that, okay, this is the CBD, near the CBD area, and the development has expanded from the city center, from the CBD to outside, and then they ran out of space. They had to build on the hills or hill slope. So these are the hilly area in Ulu Kelang lah. Bukit Antarabangsa is here. Bukit Antarabangsa. So you can see that these are high grounds, hill slopes. Okay, hill slopes. And no more space. So they had to encroach on slopes or hilly areas. Now the issues in the court. As the local authority, the Street Drainage Building Act, the SDBA, gave the local authority, in this case, Majlis Perbandaran Ampang Jaya. So Ampang Jaya was the local authority area. So this is the name of the local authority in charge, MPAJ. Okay, Majlis Perbandaran. The duties and responsibilities pertaining to building control. Okay. As such, the affected owners of Highland Towers claim liabilities on MPAJ because of the losses suffered on their units. Specifically, not the units. The court case was not initiated by the tower, by the fallen tower, by the tower that experienced structural failure. No. The court case was brought upon by the owners of blocks 2 and 3, the blocks that are still standing but were abandoned due to due to safety concerns lah. So these were abandoned. So the owners of these 2 blocks, they sued the local authority. So the court cases here, not court case, because the case went all the way up to the federal court, High Court, Court of Appeal, and then Federal Court of Malaysia. So this is the highest court, the apex court in Malaysia. There's no more appeal after the federal court. Okay. The case was known as Stephen Pua and others, 73 owners here. Stephen Pua and others versus lawan Highland Properties Neighbourhood and others as well. Okay, 73 owners and occupiers of block 2 and 3 against 10 defendants. MPAJ, the local authority, was the 4th defendant. And among others, let's not discuss because it was 73 against 10. So the case facts were quite long, but we only pick the issues related to the local authority, which is the MPAJ. Among others, the plaintiffs argued the MPAJ to be negligent pre and post collapse of Highland Towers. Now, one of the requirements to prove negligence is that you have to prove there was a duty of care and there was a breach of the duty of care. Okay. Now, negligence, and in any negligence case, the burden is on the plaintiff to prove there is a duty of care and there has been a breach of the duty of care. So, among others, the plaintiffs argued MPAJ to be negligent when pre and post collapse. Pre for allowing the construction, for not making sure that there was only 10% of the drainage, and MPAJ certified that the building was completed. Remember that was the pre-CCC time, so it was under the CFO system. The MPAJ, the local authority MPAJ, issued the CFO without checking that the drainage was only 10% completed. Okay, so negligence pre-collapse and also post, because they said that post-collapse because the local authority was not able to ensure that the 2 buildings were guarded lah, because the owners, they experienced thefts and break-ins when some daredevils, they managed to go into the 2 towers and they broke into the houses, they took away or they stole the valuables, so they were sued for that as well. Negligence for not being able to guarantee the security of their units. Held at High Court, MPAJ was found to breach. Again, this is the lowest court, the lowest in this particular case lah, the lowest court that they went. Okay, the first year, the original case, original case, MPAJ was found to breach all of his duties. There was a duty of care and there was a breach of the duty of care. The duties of care, a lot of duties, but they were given immunity by virtue of section 95 sub 2 of SDBA for the pre-collapse. They breached their duty of care, but they were given immunity. However, at the Court of Appeal, MPAJ was found liable and did not receive the immunity under section 95 sub 2. So the Court of Appeal overturned the early decision at the High Court and they decided that the MPAJ was found liable. They had to pay the damages that the claimants were asking. Court of Appeal. Now, now go back. So this one, MPAJ was found to breach. So who went to appeal at the Court of Appeal? Of course, the 10. So at the High Court, there were 73 plaintiffs against 10 defendants. When they went to the Court of Appeal, there were 10 appellants versus 73 respondents. That's how things go, yeah. So the defendant in the original case now becomes the appellant. When the case are being appealed, the aggrieved party is known as the party who is not satisfied is known as the appellant. So they went to, of course, in this case, MPAJ was not happy lah, so they appeal kan. But the reasoning behind the liability of the MPAJ is the Court of Appeal applies qualified rather than absolute immunity. So there is immunity given under Section 95 sub 2, Court of Appeal said, but it depends case by case. So it's not absolute, it's not total. You have to look at the facts of the case. In this particular case, the MPAJ punya liability was so big. So they said they rather than giving total or absolute immunity, in this case, they fail to qualify to get immunity. However, of course, like I said, the party who's not happy, they go and appeal to a higher court. In this case, MPAJ went to the federal court. MPAJ at the federal court was given full immunity for both pre and post collapse. See here at the high court, they were only given immunity for pre-collapse. So they were found liable for post-collapse. But when the case went all the way up to federal court, the local authority was given full immunity for both pre and post collapse. So this was what you call a newspaper cutting, newspaper excerpt for a news article regarding the federal court decision. It says here MPAG has full immunity from claims. Okay, whereby it says here the Justice Abdul Hamid stated local councils cannot be held liable for losses suffered by anyone should a building collapse. So this is the precedent that is being used. There's no there has yet to be a case that overturns this decision, this precedent. Say here, the state local authorities such as MPAJ were given full immunity under Section 95 sub 2 of SDBA from claims for the pre-collapse period. Okay, local authorities were made, if the local authorities were made liable, it would open the floodgates to further claims for economic loss, and this would deplete the council's resources meant for the provision of basic services and infrastructure. Again, it's purely economic argument here. Okay, and the federal court looks at what's fair to other people as well. Is it fair just to compensate a certain group of people, you bankrupt the local authority, whereas the local authority has a larger responsibility to the people within its local authority area. They need the money to operate kan. So in this particular case, the federal court decided that we close back the door from opening. There's no floodgates. We want to ensure that there's no floodgates after this that can cause the local authorities in Peninsular Malaysia to be bankrupt in case of any liabilities that they incur in the course of undertaking their duties. So in this particular case, the undertaking of duties refer to the MPAJ's responsibility in approving the building plans, in issuing the CFO, and the final one to ensure the security lah. Again, this is quite an interesting case because the first two respondents, the first was the developer, the second was the architect. The architect was actually somebody not qualified to draw a 12-story building, so negligent as well. So again, if you are interested, you can find out more about the court cases, the 3 cases from the High Court to the Court of Appeal to the Federal Court. Look online. If you cannot find any information, you can ask me. Okay, that's it for this week. Okay, after this, please do your tutorial. Thank you, everyone. See you next week. Bye-bye.